Whether you were charged with unlawful carrying of a weapon, you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on a traffic stop after the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to a signal lane change, along with the vehicle's third brake light being out. A traffic stop was conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside the vehicle. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located an unholstered black handgun inside a backpack in the back seat.
If I may, Your Honor, briefly.
Sure.
Bit unusual. I think the DPS officer, he needs help with the traffic stop. He doesn't state any traffic violations or any reason.
He does, though. Sure he does.
The DPS officer that dispatches says, hey, I'm doing surveillance on this case, on another case. I need help with a traffic stop. He doesn't tell him any traffic violations at all.
And that is true, Your Honor. The officer said he needed assistance, and the officer that was called for assistance is the one who observed the vehicle failed to signal.
So the person that came.
The person that came in response to the DPS agent calling in assistance.
We just don't know why he needs an assist with the traffic stop at all. He says, hey, come basically pull
Because he's doing something else, I'm assuming, right? Isn't that, he's investigating someone else?
Yeah, but I don't understand why he's telling another officer to pull this guy over. He doesn't give him a reason to do so. And we have videos available on this, and I've watched them.
Even so, the officer that pulls him over still sees violations, though, right? If he had not seen violations, I may have an issue.
Right.
But nevertheless, he still sees issues. I mean,
I understand that, Judge. My issue, and this may not be a thing for PC, I've watched the videos. There's no failure to signal a lane change, and you only need 2 brake lights in Texas. I don't know what this third brake light thing is. We can have a suppression hearing later on it. I just want to bring it to the court's attention at the PC determination. I mean, he says, hey, pull this guy.
You're telling me that there's no PC, and one of the issues is because he really does signal a lane change. I'm all here. I'm ready to see it. If you have it, I'm ready to see it. You know, I mean, there's no sense in delaying the inevitable. If there's no probable cause, there's no probable cause. I mean, let's tee it up. I mean, it's only 10 o'clock, right? So
Gives a moment to
of course,
yes,
absolutely. But understand, let me finish PC with everyone. Give Alex a moment to also look so he can be prepared.
Gotcha.
We'll come back. We'll take a look. In the meantime, show me the provision that says you only need 2 red lights as well.
Okay.
Show me the money, and then we'll do it.
Yeah, Judge.
Happy,
Thank you.
You know,
All right, cool.
take a seat for me in the jury box. You're on probation. You've now no.
He was, yeah, he.
Did they file a motion or no?
They filed a motion. He was taken in last night.
So let's do probable cause, and then we'll do it.
Okay, thanks, Judge.
So tell me.
A review of the body cam, we did see the failed signal. In addition, we did see the high mounted brake light out, which is a third brake light. And under the Texas Code, section 547.3215, the federal vehicle equipment safety standards are adopted, and federal regulation 49 CFR 571.108 requires a high mounted rear brake light. And because that was out, that is the.
But not all cars have that.
What?
Well,
So are you telling me now every single car has to have that third mounted brake light?
It requires any multi-purpose passenger vehicle, which in this case it was a sedan. So in this case it is a passenger vehicle. So it has to have, and you can see on the body cam, Your Honor, you can see the high mounted brake light. That's not a truck, no sedan. Well,
and I would point out, sure, it requires the vehicle to have.
No. But did you really see that there's no turn signal?
there's no turn signal, and
I would like to see that.
yeah, we can see that it's
Can you show him what you saw, please?
healthy, yeah, because she can pull up the video faster than I can.
We have the video ready.
Oh, okay. Time stamped at 0.08. It's signal. You can.
So you're going to see the vehicle come into view at a distance right there, and he comes across 2 lanes without signaling.
Bro, you can,
You can, come on, Will, you
we
can,
can show the judge that,
yeah,
because
we
you can't,
we
you
can
can't
step in
see
the
that.
back and you can see
I
it
don't think
cut
that's
across.
him.
There's no way.
There's no way that's him because
But-
he's already in the furthest right lane by the time that,
No, you
and
can see
2
him, you
seconds
can see him
later.
going across to his right, a lane without any signal and addition to that brake light as you continue the video.
Would you like to see, Judge?
Sure.
Let me see.
You will see your vehicle here.
Which car?
It's the, may I, Your Honor, go up there and point it out?
The truck.
No, it's the gray sedan. The gray sedan come up.
Oh, it hasn't come up yet.
You won't see it until after the law enforcement goes over the hill on that.
It looks like he's going pretty fast, huh?
No.
No,
No, we're just.
I promise you that. There is people kind of,
Okay, great for the next one. We can try it one night. Thank you for
So when you go, the law is such that you're always supposed to signal, right? And I mean, even if you're going in that turn,
Well,
were the lights on at that point or no?
yes, the lights were on. The lights were on as soon as he gets up to the back of my client's vehicle before he makes that turn, Vegas shade lights. And the state is saying that there was an unsignaled lane change fire.
How do you know the lights are on?
Pardon?
How do you know?
Because the sound kicks on, you can hear it.
Yeah, and he's correct that after, but before that, there's an unsignaled lane change as.
I was hoping to see an unsignaled lane change before they even pulled them.
There is, Your Honor, it just,
Show me that.
He said
yeah,
it was a freeway.
well, freeway, Your Honor. And-
Show me. I didn't see it.
Yeah, well, if I could, I can point out his vehicle.
Yeah. Show me because that's what I was looking for and I didn't see it.
Your Honor, if I may step around, so I can.
Go, please. Come on. Don't be shy.
So it's small, it's at a distance, but you'll see the vehicle come into view momentarily. It's right there. That's the defendant's
That's
vehicle.
him?
That's the defendant's vehicle. Let me go back a little
There's no way to tell it's vehicle.
bit. Because you can continue, no, and you can continue seeing it.
Can you not make it? You should be able to like,
I'm sorry, if we're gonna do crosstalk like this, we can just set this for an MAJ hearing or formal motion to suppress, and that can be up on the big screen. We can have more structure to an argument, and we don't have to have 3 people arguing about it, or that's a personal handheld device.
Yes, Judge. And that's the.
I guess you want to set it for a formal probable cause
Well,
hearing?
you know, he's on an MAJ out of this court, we just have the MAJ. It's a preponderance standard, they can challenge any motion to suppress they want to, or they can urge any motion to suppress they want.
This is for the new case though, right? This
It
is not for the
It's for the
MAJ.
new case.
It's for the new case.
Yeah, and the UCW.
The UCW, yes.
Yeah,
Yeah, but he's got a pending MAJ in this court for an evading arrest.
right. But because of this,
Right, so this would have to be proved about that hearing anyway.
right. But I'm not going to revoke if there's no PC to go here.
Right, but I'm just saying if we're going
So-
to be here, having 3 attorneys talk about a handheld device on the screen where it can't be seen, we might as well just set it for a whole hearing and then we can put the whole video up on the screen.
I'm down. You want to do it for
Well, that's what-
beginning of next week?
I mean, the court suggested that there's gonna be.
I didn't realize it was going to be this
Yeah, I just.
labor intensive, so to speak, you know?
It's turning into like a big argument. If the video is clear enough to determine probable cause, then that's fine. I'm just saying if this is gonna.
I'm having to squint. So that's why, but let's set it for a formal one. Next week, whatever you want. No?
I mean, whatever the court wants.
It doesn't matter to
I mean,
me.
but on the. I would like to do it now if we can, just annually, but I mean, it's the first 8 seconds of it.
He said it's not the one.
The car is so far on, there's no way. The state's gonna point out a minuscule car
You can,
hundreds of yards away, you can't see what lane it's in.
It's the same. It's just isn't the problem. I don't know.
there, and then the officer continues going in that direction. It's the same vehicle.
Is it that one way over there?
It's
It's this one, Mike. It's,
the one going right at that time. Because it's going right, then the officer continues in that direction, follow the vehicle.
can we see it right here? Which one is it?
So it's not right here, it's
How does he even see that?
because as he's coming around the corner, you see it right there, that vehicle right there going right.
Oh, that was cool how you did that.
Yeah, I don't know how I just you on it.
That's great. That's it.
So yeah, as
That's
he's coming
it?
around the corner, yeah, so he's coming around, and then that vehicle going all the way across with no light, and then
Look, look, look.
Can't tell what lane he's in.
No. Come here, Will. Look.
He's trying to.
He hit something that made it like really big.
And there it is, no probable cause. This is one of those jaw-dropping rulings that flips a whole case. The judge basically says, look, being a passenger in a sketchy car doesn't prove you knew it was stolen. What do you think? Should passengers be charged when the driver is dirty? Comment below. This one divides even legal experts.
Can you see if he has a driver's license, please?
It's helpful, Your Honor.
Okay. You're not allowed to drive unless you have also car insurance. Do you understand?
So I have liability.
Okay, good. Don't pick up a third case. If you pick up another case, holy moly, I'm just going to lose it. Do you understand? Don't. No, you're not supposed to have weapons. No drugs, no alcohol. Did you say there was an odor of marijuana here?
Yes, Judge, a strong odor of marijuana.
Okay, I will test you 45 days from today. If you test positive again for marijuana, I'm going to lock you up. Do you understand?
So
No more smoking weed. So let's set this off 45 to 50 days. His appearance is required. He will get another test on that day. If he's clean, we'll just continue him and then just goes normal. If he's test positive, get ready. You hold the keys. Do you understand?
sir.
Okay. All right,
Good.
guys. Thanks. Good morning, Mr. Sarmiento.
Ese es señor Sarmiento.
You were,
Bien, señor Sarmiento.
Buenos días.
you were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine.
Dólares de
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
multa, si no puede comprar uno.
Yes, Judge.
I'm going to go slow.
Yes, Judge.
Más escucho.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know, he didn't say he knows he stole it. He just didn't know him, did not give
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Right, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that, I get that, but, so He's a passenger in the car and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know,
So the trespass was, the driver driving into the area and he was this kind of.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
a scratch on the hood.
Signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. I thought you also said that the driver and.
No, Your Honor, it may be misunderstanding because of me, but the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there is enough there that a reasonable person would believe
That
he's in a stolen car.
Stolen, yes.
So the steering column, was it?
was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
Un desarmador podía apagar el vehículo.
See, I don't know, you know, because when I was young and dumb and 17, and, you know, my friend had a CJ7, you know, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
yes.
always broke down. They always had a problem. We always, you know, Jimmy rigged it as well, you know?
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
That no difference to me.
That goes to the element of without, for the criminal trespass, it goes to with knowledge that it was,
Nah, I'm not, no, I'm sorry. I'm gonna find no probable cause. I'm
Yes,
sorry.
Porque no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. Yes, sir, you're charged with theft, aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 12th, 2025, the officer responded to an HEB in Harris County, Texas, in regard to the theft of an employee. The officer made contact with the complainant, the loss prevention investigator. The complainant stated the defendant was an employee of HEB, and the loss prevention employee was notified by a store manager that the defendant was taking Red Bull into the pharmacy without paying, drinking the Red Bulls, and then throwing it away. These acts were verified by video, and the complainant researched the defendant and noticed that when the defendant left his shift, he would have a bag of unpaid grocery items, which like items throughout the store, bring the unpaid items into the pharmacy, wait until the end of his shift, bag the products, and then leave the pharmacy without attempting to pay for the merchandise. The complainant observed the defendant take items without paying in 7 different days. The total was approximately $368.38.
All right. Sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to any HEB. Do you understand? If you violate these conditions, you pick up a new case, I'm going to put you in jail. No more PR bonds. You understand, sir? Are you working now? Do you have an income?
I am studying for my board exam. So no,
Studying for board exam for what?
actually,
Really? It's not a good way to start, sir. You know, really. Look, I'll give you a lawyer today. Don't pick up any new cases. You got to understand that you got your future ahead of you, man. You want to be a nurse and now you got, come on, really? I need you to fill out an application for me. Fill it out. Let me take a look at it. I'll give you a lawyer today. Just make smart moves. It's not hard, you know, really. Come on.
Judge, was that responsive?
Yeah. Do you mind filing knowing back HEB, please? Any HEB.
Yes, Judge.
All right, Judge, counsel is approaching on page 7. Hernandez, come on up.
Hi, good morning. Hi.
Assisting Joseph Ruiz today.
I'm sorry?
I'm here assisting Joseph Ruiz today.
Okay, for sure. You are Joaquin Hernandez.
sir.
Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to 7000 Gulf Freeway, and another officer had advised that the defendant would sleep in the driver's seat of the vehicle. The vehicle was on and running, and the officer observed a container of beer in plain view in the center cup holder. The officer made contact with the defendant.
Drinking while driving?
Yes, Judge. And the officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and the defendant admitted to consuming beer, but did not state the amount. The officer observed a 12-ounce Michelob Ultra cold to the touch and a plastic bag labeled margarita to go with a straw sticking out of it, mostly consumed, and an open pack of beer in the back seat. The standard field sobriety tests were performed, HGN 6 out of 6. Walk and turn and one leg stand were not performed due to the defendant claiming he had one bad leg. The defendant was read the DIC and declined to provide a sample, and a blood search warrant was signed and executed.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has any prior DWIs, please?
Yes, Judge. I see no prior DWIs.
I would venture a guess that it's damn elementary that you're not supposed to have alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today, promising me you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to save 50 children, I can have a contempt hearing. And every time you drive, you can be facing up to 6 months in jail and a $500 fine. Do you understand? Do not drive for any reason. If you have a problem with drugs or alcohol, you better address it, because if you don't, I will do it for you. And I promise you're not going to like the way that I do it. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find anything, you're going to stay with me. No more PR bonds.
Your Honor, we'll get the opportunity to have an interlock system on this vehicle.
No, he can't drive. I'm not going to let him drive. I mean, he's got multiple open containers, all have consumed allegedly. No, I mean, and I would think that, you know, it's a privilege. And if I get that he understands the awesome privilege at a later date, come back and we can talk. But at this point, no. I will have you come up here, swear to us that you're not going to drive. After that, I'm going to get you the Victoria sign and reset. After that, what is your name, please?
Kia Smith.
I'm sorry?
Smith.
Ms. Smith. You will get to Ms. Smith where she will give you your bond conditions. After that, you'll be free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, you pick up a new case, you endanger my public, I'm going to revoke your bond and I'm going to put you in jail. Do you understand? It's not hard.
Judge, when we return on March 19, is there a possibility that we can present evidence to the court to permit the interlock?
I am always all ears, but at this point, with all that's in that car, no. But come back at a later day, show me, because it is a privilege. It's not a right. You want a right, take your Dodge Patas and take, but it's an awesome privilege, and that's what it is. Show me how much of an appreciation, proactivity goes a long way, and then we can talk. All right? Yes, ma'am.
Judge, just really quick, back in those drugs, no alcohol, is it randomly?
Please, on all DWIs, Randy Days.
And
Yeah.
it's, public device or not?
No,
Okay, right.
it's a first.
All right. Judge,
You said
next is
you said it's a first, right?
Rand,
Two first?
come on
Okay.
up.
Morning, Mr. Garcia. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 9th, 2025, officers were dispatched to a disturbance with a weapon at a Boost Mobile business in Harris County, Texas. The officers were advised that two suspects were trying to rob the store, one with a handgun and in a wheelchair. The officer observed the male matching the description inside the business, and the defendant turned as if he was going to leave. The officer asked the defendant if he had any weapons on him, and the defendant stated he did not have any weapons and that he was confused as to what was going on. The defendant agreed to the officer patting him down for weapons and immediately began reaching into his pockets, claiming he was going to retrieve his wallet. The officer observed the defendant to have an unholstered black handgun on the right side waistband tucked between his shorts, and the defendant claimed the handgun was his sister's, was borrowed for safety, and the holster was in his sister's car.
So you said they were robbing the place and
He was reported to be involved in a robbery, and that's what the officer was.
they charged?
They charged him with, no, just the possession of PCS and then the unlawful carry.
Mr. Garcia, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using illegal drugs, any kind of alcohol, I will put you in jail. No more PR bonds. As it stands now, you're on felony probation. You've now picked up a case with us, and you have a felony possession case. Is there a co-defendant in this case?
Yes, Your Honor. There actually, no, Your Honor, there's not.
You said
They allegedly had two suspects, but the officer only made contact with the one defendant.
you're not to be in possession of any weapons, no alcohol, no drugs. Do you understand?
Yes, sir.
Tell me, do you need a lawyer appointed to you today?
Yes. I'm getting one, but not right now.
I can
So yeah.
now if you want. But don't pick up any new cases. Don't be a danger to my community, Mr. Garcia, because I'm going to tell you now, I'm going to protect
I was buying a phone.
Stop. Don't say anything. Just, I want you to know that I'm going to protect my community at all costs. Do you understand?
Yes, sir.
I don't know what happened. I wasn't there. We got to wait for the evidence to come in. That's going to show us whose side is correct. I don't know. We'll get there. But just while you're out there in the free world, make the right moves. Because if I see you making wrong moves, I have only one place for you. Do you understand? Can you reach out to the Mac for Mr. Garcia, please? All right, so for now, I'm going to have you sign a receipt with Victoria. We'll have you get with Ms. Smith for your bond conditions, and then I'll have you take a seat in the jury box. Please. You are Ms. Tijerina.
Yes, sir.
Ma'am, you're charged with driving while intoxicated. Second offense, you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 11th, 2025, the officer observed the defendant's vehicle bearing an unreadable E-tag at the 6900 block of Spencer Highway. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The defendant stated she was aware the E-tag was unreadable as it was waterlogged from being so old, that the E-tag was expired as of November 2024, and that her license plates were at home but not yet on the motor vehicle. The officer confirmed the defendant was operating the motor vehicle with the wrong license plates and observed no proof of financial responsibility for the vehicle. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage. The defendant stated she was coming from a local bar, had consumed a bucket of Michelob Ultra beers, and standard fields of sobriety were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and attempted a breath. The defendant attempted to provide a breath sample but was unable to complete the test. A blood search warrant was signed and executed.
Did you say she did field sobriety test or no?
She did. Would you like me to read them again?
Yeah.
HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4.
Mr. Kitty, I'm going to find that there's enough probable cause to go forward with your case. Can you see if she has a valid license?
It's eligible, Your Honor.
Okay, I'm now placing a restriction on that license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. You're also not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond. I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
And Judge, we're fine with the random testing. She did already let me know of a scheduled trip that she has, so can we let pretrial know those dates?
You can go on your trip, but understand you're still not to use. You're going to get tested as soon as you get back. If you test positive, it's not going to go well for you. Do you understand? I don't care where you are in this world. You're still under bond condition in this court, not to use. Don't get in trouble. Make wise decisions, because if you don't, there will be disastrous consequences. And while you're out there, if you're driving, you're not allowed to unless it has an interlock on it. Do you understand?
Yes, sir.
Okay. So yeah, let Ms. Smith know about the travel, so that way.
I don't want her to get violated this.
So you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Casey, and she'll tell you when you have to come back to court. If she tells me that you've gone AWOL, she can't get a hold of you, I'm going to revoke the bond. Do you understand, ma'am?
Yes, sir.
All right. I'll have you sign a reset with Victoria. We'll have you get with Ms. Smith for your bond condition, and then you're free to go. Thanks, guys.
Thank you, Judge.
Have fun tonight. Mr. Gomez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to the 6800 block of Highway 225 within the city limits of Deer Park for a sedan stationary in lane 2 with a missing front tire. The officer observed the defendant in the driver's seat slumped over, the vehicle to be in drive, and the defendant to have his foot on the gas. The officer observed damage to the front right of the motor vehicle and the front right tire to be missing. The officer had to force entry into the vehicle to check the defendant's welfare due to the vehicle being locked. The officer put the vehicle in park and turned the vehicle off. The officer called out to the defendant, shook his arm, and administered 4 to 5 sternum rubs, and the defendant then slowly woke up and was unaware of what was occurring. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage, in addition to unsteadiness on the defendant's feet. The officer observed a buzzball chiller and beatbox alcoholic drink on the front passenger floorboard, both containers empty. The defendant stated he drank 6 beers earlier in the night and thought he was still in Houston. Extended field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to provide a blood sample.
Are you telling me that there was alcohol while he was driving?
They just found empty containers. There's no cold test, no facts indicating.
Okay. Does he have a valid Texas driver license?
All right, Your Honor.
Please. And any prior to BI, so you can run an NCIC. Mr. Gomez, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds. Do you understand?
Your Honor, no prior DWIs and life is eligible.
If you don't have liability insurance coupled with that license, then you're not allowed to drive. That's also a condition of your bond as well. Do you understand? Do you have the ability to hire a lawyer?
No, sir.
Do you want to apply for an appointed lawyer?
Sir, the thing is, I'm actually on probation for a different.
Stop. Just don't. All I want to know is you want a court-appointed lawyer?
Yes.
Okay. I'm going to appoint you a lawyer today. Just don't say anything. I've got a bunch of DAs here. Whatever they say, they can use it against you. I'll have you sign a reset, Victoria. We're going to give you an application. We will eventually meet with Ms. Smith, and then we'll appoint your lawyer.
Yes,
okay? Leave.
Good morning, Judge.
Hi.
How are you, sir?
You standing in for Mr. Butler?
I'm standing in for Mr.
Okay,
Butler.
wonderful.
I'm a Mac attorney as well.
Okay, great.
Okay.
Thank you.
Good to see you.
Okay. Good morning, ma'am. Ma'am, you're charged with you are Ms. Greeny. Okay, Ms. Greeny, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. Okay. On January 9th, 2025, the officer was dispatched to 1100 Siegler Road regarding a major crash, and the officer observed the defendant outside her vehicle talking to Houston Fire Department. The defendant's vehicle was in a ditch with apparent minor front end damage, was on and in the in-park position. The defendant appeared disoriented, had poor balance, and was not able to stand unassisted. The defendant stated she had the motor vehicle's key fob in her pocket, and the defendant was taken to HCA Healthcare, and the officer then went to HCA to obtain a statement. The officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant stated she did not strike her head or lose consciousness due to the collision and drank between 1 to 10 12-ounce Miller Lite beers prior to operating the motor vehicle and getting into the collision. The defendant further stated she could not remember the time she drank her last beer. Standard field sobriety tests were administered. HGN 6 out of 6. Walk and turn and one leg stand were refused as the defendant stated her balance has always been bad. The defendant was read the DIC and a blood search warrant was signed and executed.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds for you, ma'am. Any prior DWIs?
No, Your Honor. And her license is eligible.
Got it. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will revoke your bond. Don't pick up any new cases, and that's it. Okay, so I'll have you sign a Rita Victoria. We'll have you get with Ms. Smith for your bond conditions, and then you're free to go. Thank you, Judge. All right.
See you.
You too. Take care. Mr. Jackson, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 10th, 2025, the officer observed the defendant's vehicle traveling east at the intersection of 2200 block of Spears Road and TC Jester with a defective license plate light. The traffic stop was initiated and the officer made contact with the defendant. The officer observed a strong odor of marijuana emitting from the vehicle and a PC search was conducted. The officer located a green leafy substance believed to be marijuana based on training experience in the driver's side of the vehicle. The weight was approximately 1 ounce.
Was it?
It was on the driver's side.
All right, Mr. Jackson, I'm going to find that there's probable cause to go forward with your case. You run his license.
Not eligible, Your Honor.
If you don't have a license, you are not allowed to drive. Do you understand, Mr. Jackson? You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance, come back to me, and I'll take this restriction off. But I'm going to tell you now, if I find that you drive, I'm going to sprout horns in the tail. Like, that's how upset I'm going to be. Do you understand? Tell me, did you want to apply for a court-appointed lawyer? Do you mind giving me, please? Okay. Tell me about yourself. What do you do these days, Mr. Jackson? How old are you?
23.
So what plans for the future do you have? What? Why?
I gotta get it renewed. Yeah. That's all. I just gotta get it renewed.
You have the ability to make it's just a boatload of money with that license, and I don't understand why you're gonna let it expire. I'm making it a condition that you get a job. You need to get a full-time job. You know that, have you ever explored underwater welding? Have you ever looked into that? How much money do they make? No. How much money do they make? How much is that a year? That's probably like 120, 130 a year. You can make sick money. And come on, man, be better. All right. So do you mind giving me the application? I'm telling you, I'm gonna stay on top of it to make sure that you get that thing back and that you're working, that you're making some good money. Do you understand? All right, come on. Sir, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 9th, 2025, the officer observed the defendant's vehicle traveling at the 7600 block of North Wayside Drive with the defective front headlight not illuminated. The traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The defendant provided a Texas driver's license, but was unable to provide proof of financial responsibility. The officer found the Texas driver's license to be not eligible with an active SR suspension, and the defendant was the registered owner of the vehicle, and the insurance database showed insurance policy for the vehicle had expired as of March 14th, 2024.
Got it. All right, Mr. Pickney, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to drive. You will be signing an affidavit with me today promising me you're not going to drive. This is a legal document that you're going to swear to me. If you violate this, I can have a hearing. If you prove it to me that you're driving, I can have a hearing to hold you in contempt and hit you with up to 6 months in jail every single time. Do you understand? So if you drive 5 times, I can have 5 different hearings. Do you understand? Yes or no? Do not drive. If you want to, go get your license, get insurance, come back to me, and I will so happily take this off, but just don't until you do that. It's not hard. You understand? Bless you. Did you want to apply for an appointed lawyer? You know, I had someone send me an email not too long ago where they were in an accident and created $50,000 worth of $50,000 worth of damage to another person, and they didn't know what to do because they ended up just getting sued. Person filed a lawsuit against them, is coming after them. They're, what do I do? What do I do? This is solved by having car insurance. When you're in an accident, that's why we have insurance. So it's not a joke. You look at me like it's, but I'm being serious. I'm trying to help you. Don't, right. Do it the right way. Great things will happen for you. I'm going to give you a lawyer. The lawyer can try to help you out with what you need to do to get your license back. But there's no excuse. If you get into a car, I'm going to lose it. Do you understand? Okay, come on.
So that was a no driving affidavit?
Yeah.
That's it?
No, we'll do bond conditions as well. Do you mind following that? No driving without license and insurance, please.
All right.
Mr. Simon Fournier,
Yes, see,
Yes.
we're charged with theft. You are facing up to a year in jail. I'm sorry, up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you do not have a lawyer, if you cannot afford one, one will be appointed to you, sir.
Signaría uno, señor.
Yes, Judge. On January 11th, 2025, the officer responded to a Walmart in regard to a theft. The officer made contact with the complainant, and the complainant observed the defendant at a self-checkout with a large amount of groceries. The complainant observed the defendant failed to scan every item in the cart. The defendant was confronted on 2 separate occasions during the checkout process. The defendant was told how to scan items properly, and the defendant failed a 3rd time to scan items properly. The defendant completed the transaction and had unpurchased items past all points of sale, and the total was $184.48.
Sir, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart. If you violate this condition, I'm going to put you in jail. I don't know what your immigration status in this country is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in there until this case is over with and then shipped off to immigration. Behave yourself, otherwise I'm going to lock you up. Do you understand?
yes.
Yes.
You have the ability to hire a lawyer.
¿Ocupar un abogado?
Sí, me lo ponía
Yeah.
aquí.
Yes, can you give
Do you
me
want to
one
apply
quick?
for a lawyer?
¿Quieres aplicar por un abogado de oficio?
¿Yo puedo hablar?
Can I speak?
No,
No.
but you can have a lawyer if you want one.
Puede tener un abogado si desea.
Sí,
Yes.
You need a lawyer.
Necesita un abogado.
sí.
Yes.
Okay. I need you to fill out an application for me. I'll have you sign a receipt with Victoria. Wait, we're not done. Do not leave until you sign our bond conditions prohibiting you from going to any Walmart.
Entiéndolo.
Do you understand?
¿Usted lo entiende?
Now you're done. So, Mr. Duran, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Okay. On January 11th, 2025, the officer was on patrol and observed an odor of marijuana and a male to be smoking in a vehicle nearby at the 8700 block of Lazy Brook Lane. The officer activated emergency lights, positioned himself behind the motor vehicle, and made contact with the defendant. The officer had the defendant step out of the vehicle and advised the defendant that he had been observed smoking marijuana. The defendant stated he was smoking marijuana inside the vehicle because he did not want to smoke inside his friend's home. The officer observed a strong odor of marijuana and conducted a PC search of the vehicle. The officer observed small crumble of green leafy substance known to be marijuana based on training and experience at the bottom of the center console, and 0.37 grams of a small marijuana joint in the ashtray in the cup holder. The officer observed an unholstered black Glock laying in plain view on the backseat floor, and the defendant stated the handgun belonged to him.
Mr. Duran, I'm going to find that there's probable cause to go forward with your case. You see if he has a Texas driver license, please.
Don't worry on it.
All right. You're not allowed to drive unless you have a license and liability insurance in your name. Those are conditions of your bond. Do you understand? Those are the only conditions I'm going to put on you. Be careful. Don't do anything stupid. Do not pick up a new case. Otherwise, I'm going to revoke your bond. I'll put you in jail. You understand?
Yes, sir.
You have a lawyer. Listen to him. He'll take care of you. Because you have him, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get a hold of you, you pick up a new case, become a danger to my community, I'm going to revoke your bond, put you in jail. So you understand? All right. So the only thing is just don't get in trouble. Don't drive without a license and insurance. Okay?
Yes, sir.
All right. We will have you just sign the bond conditions, and after that, you'll be free to go. Okay? All right. Thanks.
Okay, this moment is wild. The judge is literally squinting at a handheld video like it's a Bigfoot sighting. This is classic courtroom tension. Defense says no lane change, state says yes lane change, and the judge is stuck in the middle. In Texas, even tiny traffic violations can justify a stop, but only if they actually happened. This is exactly why suppression hearings get messy.
Adrian Johnson was supposed to have had a court date here on 12/12/23.
23?
23. Oof. However, Adrian Johnson, during that period of time, had gone to Atlanta, Georgia. While he was in Atlanta, Georgia, he picked up a possession of marijuana case where he spent one day in the jail and he got out. He didn't get out. Instead of getting out, they transported him to Appleton, Georgia, where he picked up a theft case, and he stayed there 13 months. Therefore, his reason for not being here on time was because he had went to Atlanta, Georgia, picked up a possession of marijuana case. Then when he got out, they didn't let him out. He had already had another warrant on him for a theft case up in Appleton, Georgia.
Do you have a cause number by chance?
Yes, sir. We have.
No, for our case here.
Yes, sir. 247-6875. 247-6875. Adrian Johnson. So I'm respectfully requesting to reinstate his bond or give him another PR bond, Judge.
Mr. Johnson, you were charged with burglary of a motor vehicle. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 22nd, 2023, officers were dispatched to a lawn management company at 630 Rankin Circle for a burglary in progress. The defendant and a co-defendant had cut through the fence surrounding the property and were searching through vehicles at the location. There are surveillance videos of the defendant and co-defendant inside a van on the property.
Can you run an NCIC on him? I'd like to know what, if anything, has happened from the time that he picked this case up to the time he's now back in front of us.
Yes, Judge.
I don't know, Mr. D. Guys, he has a warrant for now, and I don't know if I'm going to give him a PR bond. I want to see how he's been since September 23. If you've been on picking up cases like it's just left and right, then I don't know, man, but
Yes, sir, Your Honor.
my only concern is my community. That's all I care about, and I'm going to do everything in my power to protect my community. If you've just become a danger where you're hopscotching states and you're playing hopscotch and you're picking up cases while you're hopscotching, no. The revolving door closes.
Well, I do see on December 7th, 2023, the Georgia case theft by taking, but that's the only other case.
Is that a felony or was that a misdemeanor?
It's felony, Your Honor.
What was it? Do you have a disposition?
No, there's no disposition listed.
13 months per him, Judge.
Anything else he's picked up?
No, Your Honor.
I have the, oh man, speak. All right, let's see.
Got back to Houston on January the 20th.
I'm going to reinstate your bond now, but I'm not going to do it again. If you take flight on me again, I'm telling you, I'm going to make it high. No more PR bonds for you. You got a little kid in your charge, man. Be the good father that you should be. Teach them right, because they look on you for support and for them to do the right way. They see this. We don't need more. Know what I mean? Come on, man. Be better. I'm placing bond conditions on you now that you're not to go back to this location where this occurred and you're not to be in possession of weapons. Don't pick up any new cases. You've got a great lawyer here. Just listen to him. He'll take care of you. If I find that you're becoming a danger, you know what's going to happen. I don't have any tolerance. We have nothing but death and destruction on the news. I don't want any more. Do you understand? So, all right, man. Good luck. Don't leave until you sign the bond conditions. Okay.
Thank you.
That states bond conditions?
Yeah.
You said bond reinstated?
Yeah. What happened? The three kids, they didn't take off, did they?
Can I ask if they checked?
There's one.
Pretrial? Oh.
Okay. All right. You ready? Mr. Bada, Mr. Segun.
Yeah, I'm right here, sir. Can you hear me, sir? Your Honor, can you hear me, sir?
I can hear you. And let me tell you now that I really haven't seen a lawyer go above and beyond the call of duty as Bayoshi has done in this case. Everything and every time you have been back here is because of something that has happened, or I'm sorry, something that has failed to happen. The last time here, all you had to do was provide documentation that you could not afford whatever it was. You have failed to provide that documentation. As a result, they've now kicked you out of the program. I know that Bayoshi is going to give it one last shot as to whether he's able to either get the case dismissed, get you back in. I don't know. But I am now putting this baby to bed. So I will give you a week. Is that okay?
Yes, Your Honor. That should be enough time.
I am not waiving your appearance anymore. And in the next week, if he is unable to get you back into the program, if he is unable to get the case dismissed, you must either accept the plea bargain agreement from the state, or I will immediately set your case for trial, and it's going to be a very short trial setting. Do you understand?
I understand, sir.
It's unacceptable that we are now at 800 days, and they have literally over and over and over bent over backwards to help you. And if I were you, I would probably just, you know, I can tell you now that Bioshi's not very happy with you as well.
I'm not happy with myself too. And
So
I don't have power over the old situation. My
I do
cab
look,
blew
I'm
off.
not,
My
I don't want you
my
to say
mom just
anything.
died a month
Don't
ago.
say anything. There's
Okay.
nothing you need to say. The only thing that matters are actions. You telling us something makes no, it goes in one ear, it goes out the other ear. Because when you get out there, we still have issues. So I don't care. I'm giving Bioshi a week to do what he can do. If it doesn't work out and it doesn't end up getting dismissed, you must be here in court. If you fail to appear, I'm going to revoke your bond. Do you understand?
I understand, sir.
Thank you, Your Honor.
Hold on. Before
Thank you,
he
Your
leaves,
Honor.
I want to give him the date.
Oh, yeah, you need to.
Don't go because I want to give you the date so I can mark everything down so that you knew exactly what day and what time you had to be here.
Okay, sir. I'll be there.
What day do you want, Bioshi?
Your Honor, we can literally do this time next week, the 24th.
If you need a little bit more, because I know how busy you are, I'm happy to give you an extra week if you want.
In 2 weeks' time, then that would be the 30th.
Yeah, but don't pick a Friday because Fridays are busiest with arraignments. So like perhaps like a Thursday or whatnot, you know?
Okay, I'll pick, okay,
You want that Thursday?
let me just double check that.
That would be
That would be Thursday, the 30th.
30th. You want to do that? And because of how great you have been, Bioshi, that, but
I appreciate Your Honor.
Yeah.
Thursday, the 30th works.
on page 13, top of 13, SFBF 130, please. All right.
Thank you, Your Honor. If you could-
You must be here January 30th. If the case is still active and it doesn't get dismissed, you must be here in person on that day and either accept a plea bargain from the state or we will immediately set it for trial. Do you understand?
Yes, sir. Thank you.
All right.
Right away, the judge is laying out the stakes, and they're big. But pay attention here. This case hinges on probable cause, not the gun itself. Do you think a traffic violation should justify a full search? Let me know in the comments, because this officer's reasoning is about to spark a debate.
This is not a good way to start in life. I can tell you now that if you don't have a high school diploma, you will make pennies to when everybody else is making dollars. You will never have a good job in this life at a minimum without a high school diploma. Knowledge is power, and if you don't set yourself up for something in the future, you're going to end up destitute. 90% of the marriages that are end up in divorce now is because people have no money. They fight constantly because they never have money. And it all starts now when you're 17. And it starts by staying in high school. I want you to do that. I'm going to bring you back in 2.5 weeks. I want to see what you have done to get back into school. If you need help, I can give you resources so that we can sign you up for free GED classes. Because I don't know if you're old enough to get back into high school. But if you want, I can give you resources now so that you can start with GED classes. That's fine with me. One more thing. No smoking weed. I will test you 45 to 50 days from today. If I find that you're smoking weed, it's not going to go well. You get my drift.
Yes, Your Honor.
If you stop as of now, the next time I test you, it should be negative. If you continue to use, you understand?
Yes, sir.
You must stay in touch with Ms. Oakforth. She'll tell you how to handle this case and what you need to do. If she tells you that you're playing games, I'm going to put you in jail. No more PR bonds. All right? Do you understand?
Yes, sir.
Good luck, man. Make me proud. Come on.
Yeah.
What happened to the third kid?
He hasn't made it back yet.
Okay. So no more.
Yes, sir.
You're not to. And I'm going to test you again in 45 to 50 days. If I find that you're using, it's not going to go well for you. If you stop as of right now, in 45 to 50 days, you should test negative. If you keep smoking, it's not going to go well for you. You also need to get back into high school. This is not a good way to start in life. If you need resources, we have it for you.
I don't got my diploma, but I got my certifications to like work at the refineries. So I can't even work.
You need your high school diploma, man. That's what I'm trying to get you to do, you know? And I have free classes for you to be able to do it. And I can give you the paperwork, so it's not going to cost you anything. But at a minimum, if that doesn't work out for you, you need something to fall back on. You know what I mean?
Yes, sir.
All right. We're going to give you that paperwork. I'm going to bring you back. I want to see that you're doing well.
Yes,
All
sir.
right? Okay, man. No more smoking.
Yes, I understand.
Okay. All right, guys.
God bless you.
He's back. Oh, yeah.